5 minutes past 10, our talkback lawyer David Whiting is here to help you with free legal advice for Law Week. Well, he's here every week, but it is Law Week, which we shall celebrate in a moment. The number is 1300 222 774 if you'd like some free legal advice. 1300 222 774. David, good morning to you.
Good morning, John.
The CEO of the Law Institute, the umbrella body for Victorian solicitors, suddenly resigned yesterday.
And left yesterday.
And left on the same day in what I understand has been an increasingly tense internal environment, including attempts at mediation over the last few weeks between the Council of the Law Institute and the CEO.
All I know is what I got from the press release, John. I'm on the Law Institute's press release list, so I got the press release. I got an email from the Institute, and then the Institute sends out a daily update, and it was on that as well.
Do you not know any of the context or the background?
None at all.
The Victorian Law Institute now covers and has the membership of about 60 to 65% of Victorian solicitors only. So
there was a time when it was compulsory, and what you also find, though, John, is that a number of national firms tend not to join.
Can't see the point, don't see the relevance, and have their own networks for training and all the rest of it as well. Yes. But in New South Wales, the equivalent body, the Law Society, has 85% membership.
Perhaps they've got our members, John.
No. They have a different method of dealing with complaints against lawyers there, and ours, even though they're based on the same rules, have been interpreted differently, and the carve-up of responsibilities here has been different, and thus the Law Institute in Victoria has become less and less relevant to the working lives of more and more practitioners who then say, well, why am I paying them all this money? I don't get anything for it.
Well, my frustration, I'm a member of the Law Institute. I've chaired a committee
I was for many years,
Institute.
But I should also say I no longer am, yes.
Oh, well, and when I read their material, my view is that that they put too much effort into lobbying and, in a sense, to change the law in a social sense, and I say that they ought to be, that their primary role ought to be to ensure that lawyers are able to run, effective and proper practices. So
there's been a long-running attempt. Nerida Wallace is the CEO who's just left yesterday. There was a long attempt after she was appointed to the position to try and adjust everybody's expectations, and that failed. And so as it went through declining relevance, declining membership and declining clout, the frustrations of people boiled over, and eventually it led to her being asked to leave, which she did with an announcement yesterday. They've gone into the bunker, apparently, the last few days. So, yeah.
You should read their press releases, John.
I do read their press releases, but I, in fact, heard about this well before the press release came. Belinda Wilson is the president. She's going to be the acting CEO for the time being. And
it's a mammoth job, John.
It's a mammoth job, and also she's in her second term, which is extremely unusual. There's usually only 1 year at a time, and someone is groomed to be the next year's president, and that process fell apart too, which is part of what's gone wrong here.
Oh, well, I hope they get it right.
Well, it's going to require a lot of... Well, we'll see whether or not it requires what it requires. One of the things it requires is a huge amount of energy.
Absolutely.
So
I hope they've got it.
Watch this space. Meanwhile,
Law Week.
Law Week's underway.
Law Week started yesterday and it's running until next Sunday. Their press release as to what's on in Law Week runs to 18 pages, and some of it I'm already missed, which disappoints me. There was a mock coronial inquest last night at the Coroner's Court. A couple of things that caught my eye. There is the death of a partner, a launch of a booklet by the Council for the Ageing on Wednesday. There is a day in the life of the accused, so you can be a defendant in a criminal matter, locked up in a holding cell. You can do that Saturday at the County Court. Can I suggest lawweek.net.au for the list of what's on? And there are lots of them in regional areas as well. So I think I'd be positive. There's an address on what's parole in the court system at Geelong on Wednesday. So lawweek.net.au.
I've been cleaning out some old files from old filing cabinets.
Yes, so that's what happens when you move to open plan, John.
I found a file from Law Week 1986, I think it was, or 87.
Yes.
And I was chairing a session on opening up the courts for public scrutiny. And joining me on the panel were the newly appointed magistrate, Linda Dessau.
Yes, well, she's kicked on.
She's kicked on a bit, yeah. She's now the governor. Sally Brown, who then kicked on to be, I think, the Chief Magistrate. Chief Magistrate. Mm-hmm. And there was another woman on it, Jenny Coate, who also has just been a Royal Commissioner on the Royal Commission. So I found this brochure and I thought, well, that's funny, and then I threw it in the bin because it was all getting chucked out anyway, but it gave me a bit of a giggle.
I was involved in the first Law Week. I was an article clerk, and Channel 10 was a sponsor to the first Law Week. So we did I was the defendant and I was locked up for a short period of time and interviewed.
What were you charged with?
The honest answer is I can't remember.
Larceny? Consorting?
Probably something horrible, but it was in the police station at Nunawading. So
okay.
Terribly unattractive even then.
Did you actually get locked up?
I was in one of the interview rooms.
Okay.
So, no, their cells, no, they left me out of the cells, and while they closed the door in the interview room, they didn't lock it on me, John.
And they didn't introduce you to a phone book and the interrogation techniques that accompany the phone book?
I'm sure that never happened, John.
It did happen. It used to happen all the time. I hope
they left less bruises, as I understand.
I hope it does. That's right.
John, I have two short things for you.
Yes.
The first one is that there's a provision. Some years ago, there was an issue that they had with estate agents about what they call advertising rebates. So the agent would charge you for advertising, and they would then get a rebate, or in unkind terms, a kickback from the person with whom they placed the advertising. As a result, there was specific wording required to be included in disclosure documents issued by estate agents to their clients. Now, there was a claim over $365,000 commission for an $8.8 million sale on a property, and the county court found that the estate agent who had used a pre-printed form was not entitled to commission because they didn't use the precise wording in the legislation. Same intent, not the precise wording.
So what did they get wrong?
I think they might have left out a two-letter word or something like that. It certainly wasn't. No. There was no dispute about the meaning. Yeah. There was dispute about the precise words.
Right.
The Court of Appeal decided last week that the estate agent was wrong and was not entitled to its $365,000 commission. Wasn't entitled to commission at all.
Whoops.
Yes. So there will be a large number of people who have sold properties in the last 5 years who have a form that looks just like that. So... And I had a caller from last week who bought a block of land on a retired golf course, was advised that there would be a metre of fill on the land, and in fact there was 3 metres of fill on the land when he purchased.
And it took some time for this to be
Well, you're not
notified.
aware until you've settled.
That's right.
Because you're told where it is, and the answer is there's a positive obligation in the Sale of Land Act to disclose alterations in the natural surface of the soil. It's an ongoing obligation. So if you are the developer and you need to go from 1 metre to 1.5 metres, there's an ongoing obligation to disclose. So there is an action against the developer, probably for deceptive and misleading conduct and probably breaches of the statutory obligation.
So you would take proceedings in that case in the federal court and avoid the state courts, which are a bit more clogged up?
Could do, or you would start the negotiation. The difficulty, John, is... Are you entitled to the difference in value of the blocks, which I would have thought would be negligible, or are you entitled to the additional costs that you will be put to as a consequence of your need to change your building works? It's the difference of, are you entitled to your rights in breach of contract, or are you entitled to your loss measured on tort?
Okay, and that will dictate your jurisdiction then.
Well, it'll certainly dictate the amount you get.
Yeah, totally. Yep. Peter from Lancefield's first up with David today. Morning to you, Peter. Thanks for holding on.
Morning, John and David. Thanks for having me.
Go right ahead.
My question concerns the legal liability for adverse consequences caused by straying livestock.
Yes.
What's happened?
It hasn't happened. I've got a big bill for business liability insurance, and I want to know whether I should pay it or not.
Oh, I haven't read the PDS, Peter. You probably haven't either. But you're asking about straying livestock. You, as the owner of the livestock, have a responsibility. The old English law was that you didn't. That was changed by legislation probably 25 years ago, and effectively the same rules of negligence apply.
Well, what if it's not negligence? What if it's...
You mean deliberate? Then
well,
you could.
either deliberate or accidental, caused by falling trees or floods or fires or gates left open by third parties.
Well, then if the gate was... I would buy the insurance, Peter. If a negligent if a third party leaves the gate open negligently, then the argument would be that you failed to adequately secure your stock because you've not taken account of the possibility that some trespasser might choose to leave the gate open.
Well, I mean...
If a tree is struck by lightning and falls over, then I'm not worried about your liability.
So if it's due to a falling tree, it's all right?
No. Depends on what causes the tree to fall. We have, every now and then you'll see a case that involves an issue as to whether the trees have been properly looked after or husbanded.
If they're
and
on
there are
private
some
land,
kinds
you
of
can't
trees...
look after them and husband them.
I beg your pardon?
They're on public land, then it's not
No,
your...
then that's not your problem. It's when they're on your property, in respect of you, which you want insurance, that it becomes your problem. If you're going through a national park and the tree falls on you, that's the state's problem. You've got a different problem, but the insurance risk is the state's, not yours.
Yeah, my problem is really that, that interpretation means that I have to be pretty well patrolling my boundaries every single moment of the time, because there's no way otherwise that I can know that some of these events have occurred.
Can I say that's one of the reasons why you have insurance? No one expects you to police every second of every day, and we talk there about, a cordial bottle that falls in an aisle in a service station. In a supermarket. There's no expectation that there will be someone with a bucket and a mop standing at the end of each aisle, constantly looking for such things. There's got to be a reasonable level of vigilance, and my view is that if you were being prudent, you would take out insurance.
Hope that helps you, Peter. It's an issue that's very, very lively, in particular, right across regional Australia. Louise and Bendigo, good morning. You're through to David. Louise.
Hello.
Yes, you're on here now.
Sorry, I was taking it off speaker.
Yes.
Thanks very much, Jon, David, for taking my call. Just a question regarding wills, which you probably have dozens of.
More than one.
My father remarried probably about 20 years ago, and unfortunately...
Sorry, struggling to hear you, Louise, even though you've taken us off hands-free. Go again.
Okay, I'll try and speak. My father remarried about 20 years ago, and she ended up passing away from cancer. And she had 2 children, which all of her assets went to them.
Yes.
Then, with his current will, he's been very open, and in his will he said that he's leaving money to his stepson from that marriage.
Yes.
He's going to leave the rest of his estate to my brother and I, and he also is about to get remarried now.
Yes.
And his partner, future wife shortly, she's able to live in his, the house.
He's giving her a life interest in the house, is that right?
Yes, that's right. And she can have if he passed away, she can have a partner, but she can't actually renovate the house or do major works to it unless my brother and I agree, and it can't be used as collateral for another property.
So what's the question, Louise?
The couple of questions are, his first stepdaughter, in his will he said that there's no other people to be entitled to any of my will. So one, is his stepdaughter able to contest that since his first stepdaughter, since he says that in the will? And for when he gets remarried, she has 3 grown-up children. So can they then also contest the will?
Children and stepchildren and step-grandchildren all have the ability to contest a will. But in terms of adult, the thought process goes that whatever rights her children have would really come out of what she might be entitled to claim, and what she's entitled to claim would probably be very low, if anything, because it needs to take account of her ability to look after herself. So does she does she and her children have the right at law to contest the will? The answer to that is yes. Do I think that they are likely to succeed? My view is no.
And with his self-managed, he's got a self-managed super and separate super funds and shares as well.
Yes.
No doubt he will want to make sure that she is well looked after, which he will make sure that happens. How does that go? Because he was confused as to what happens with self-managed supers.
Well, he still has the right under his self-managed super fund to decide whether his superannuation is going to his estate, to his wife, or to his children, or even to his stepchildren. So that's up to him. But I would start from a different premise, and I'm mildly cautious about what you're saying, Louise. I would be trying to get some advice as to whether his wife-to-be is adequately provided for by the arrangements that he's putting in place. That's the bit that I'm anxious about.
All right.
If the marriage lasts 5 or 10 years or longer, is the provision that's being made constitute adequate provision for the person involved?
All righty.
So he needs to make sure that.
He needs to get some advice. I know what he wants. He needs to make sure that he's in fact adequately providing for her.
And circumstances change over time is the other thing, Louise. What prevails in 2018 may not be what prevails by 2028.
So if he dies 6 months after he gets married, then I don't have any doubts about the will. But if he dies 10 years after he gets married, I don't know whether that's still reasonable.
Okay.
Thanks,
Is there a
Louise.
special form he has to fill out for that, for his super fund to nominate people?
It's called a binding death benefit nomination form, and you can get them on the net. But if he's got an accountant, if he's got a self-managed fund, he will have an accountant. They can get the form for you.
Alrighty, I hope that helps you. Text message from Catherine saying, I'm a sole practitioner solicitor. I resent having to pay $1,400 each year to the Law Institute just to keep my family law accreditation current. I'm forced to remain a member of this otherwise useless body to retain my specialisation. All I get is the monthly magazine and I never read it.
The Law Institute has specialist accreditations in a number of areas of law, and it's considered to be a marketing advantage. You can be a incredibly experienced and well-regarded practitioner without having the specialist accreditation.
But if you're a personal injuries accredited specialist, you can put that in your marketing, put that on your
letterhead. You can
letterhead
do
and
all of those
brochures,
things,
and
yes.
that helps you get work.
So you're paying not for the membership of the institute, but for the accreditation. Well, sorry, the accreditation of specialists only applies to members. So yes, she does need to pay that amount of money to maintain if you like, the badging, not the skills, but the badging.
She's saying it's not value for money, and I think there's plenty of people who feel the same way, basically. David in Geelong. Morning to you, David.
Yeah, good. Thanks, John. And Dave will take my call. My question is regarding my partner, who's it's a workplace question. She's a casual worker. She works at a pretty large retail store. Now, she's been a casual worker for just going on 14 years.
Yes.
Everyone else around her has been made permanent part-time where they get a contract for a certain amount of hours per week. She's lucky, if she's very lucky, she'll get 3 hours per fortnight.
Yes.
But normally it's about 3 hours per month. For 14 years service and not to be offered a part-time position where she gets set hours per week. Everyone else is younger than her that have been made permanent part-time. And just one starting, it looks like a bit of discrimination against her.
And what do you think is the basis of the discrimination, David?
Not real sure.
But that's your starting point, because not all discrimination is unlawful discrimination.
Okay.
So, and it may well be that there could be lots of reasons, and if it's an unlawful discrimination, your partner has a claim for damages. If it's not unlawful discrimination, she doesn't.
Yeah, I understand, but again, 14 years service, and in that 14 years, she's only knocked back I don't want to blow her tyres, but she only knocked back 2 shifts. And once she was in hospital, the second time was our son's wedding. And she had never had any warning.
Then, David, she needs to ask. I would have come along and said 3 hours a month for 14 years, I'd either be expecting permanency or a new job.
Absolutely.
But ask.
Well, she has asked, and they keep telling her we're going to try and find you more hours and that. And it's the same old story. They doing this and offering that and that, but it just goes in circles. The store seemed to change over its manager quite regularly, and
then I would be sitting down and trying to analyse from each of the people that they've, say the last 5 or 10 people that they have moved from casual to part-time, and try and work out what it is, and perhaps you might put it to them. It might be that it's an age-related discrimination which is unlawful, or it might be a basis for discrimination that isn't.
Good luck with that. Robert in Doncaster, good morning. You're through to David Whiting.
Oh, good morning. Thanks, John and David. I really need your help. I've signed an off-the-plan contract of sale for a unit 11 months ago, and I won't be able to... the plan of subdivision is going to be registered shortly. I won't be able to settle because I can't get the finance for one reason or another.
Yes.
The contract is a very flimsy one prepared by a conveyancer that doesn't have any special conditions whatsoever, other than just a list of the inclusions. It's a townhouse unit off the plan.
Yes.
There's no sunset clause.
There is a sunset clause implied by legislation.
Right.
And the sunset clause, the standard clause for if you're buying land off the plan, then there's a 18-month period for registration of the plan. Sorry?
Do they have to insert that?
No, it's a special condition implied by law.
In the statute.
In the Sale of Land Act.
Did you pay a deposit, Robert?
Yes, I did.
How much?
5%.
So how much money?
5%, which is say $20,000.
And you want that back?
Yes.
David.
Then, Robert, I would be sitting down with a lawyer to go through the contract line by line to see if they've failed under one or more of their obligations in the contract.
Right, okay.
They'll be quite happy to let you out of the contract but keep your $20,000. But if you want your $20,000 back, well, sorry, when I say quite happy, they may not be, but that's one option. But if you want your $20,000 back, that's quite a different proposition, isn't it, David?
Yeah, there's also a certain artificiality about prices in off-the-plan lots. And because, if I'm buying a lot in your building, Robert, you're the person who's worked out what they're worth. There is no market. And what you will often find is that units bought off the plan will value, for apartments particularly, will value at slightly less than your contract price.
Has it actually been built, Robert?
Yes. In fact, settlement's going to be coming up, I'd imagine, in about 3 weeks' time.
Okay.
Then I would be taking your contract off to somebody and say, when you look at the obligations they've got under the Sale of Land Act and any other piece of legislation you can find, have they met their obligations or haven't they?
Right. Any tips?
Well,
how long's a piece of string?
Yeah, I regularly see off-the-plan contracts with 40 pages of special conditions.
Yeah, no, this one hasn't got that.
Well, is it worth spending a bit of money to try and get 20 grand back is your question.
Yeah, sure.
Is the unit being built precisely as required?
And so on.
No,
because there are provisions in the Sale of Land Act that enable you to avoid contracts that don't accord with the plan in the contract when you bought it. So you might consider that.
All right, good luck with that. Greg in Park Orchards, morning to you too, Greg, and thanks for holding on.
That's okay. Good morning, John and David. Just a query about suspended licence. About a month ago, I was pulled up by the police and told that I was driving on a suspended licence for the last 10 months.
Whoops.
Well, sorry, what they're really telling you is that your licence was suspended 10 months ago. You were only driving yesterday. Yep.
Sorry,
yes.
And I was driving about a month ago.
Yes.
And what had happened, I'd gone through a red light arrow, and I felt like there was something wrong at the time when I went through it. So I did get an infringement notice. 10 days after I did this, I went back to where the intersection was, and there was a fault with one of the red lights. But
Yes.
anyway, I queried that with them, and that was a big mistake because I lost the argument. I went through a red light camera, end of story.
Yes.
I went back 10 days after to look at the site. The red light was still not operating properly, so I rang the signals office and told them. And they said, "Oh, okay, mate, the other lights are working, aren't they? But we'll fix that." And that was fixed within an hour of me
Yes.
ringing.
Yes.
Anyhow...
You rang the wrong people. You should have rung the people who issued you the ticket.
Greg, have they prosecuted you
sorry,
now
I
for
did.
driving while suspended?
I did ring about having the ticket.
Sure. Greg, I just want to move on to now.
Yep.
Are you being prosecuted now for driving while suspended?
No, I'm not being prosecuted, but I was driving my car for 10 months under a suspended licence. I was teaching my granddaughter how to drive. I did all the things that I was supposed to do, which was to go and I expect...
Greg, you got the ticket. They suspended your licence. You will have received notification from Vic Roads of the suspension. Do you say you didn't get the notice?
I got the notice. I rang and queried the fact that I went through that light.
No, Greg. It's up to you to fix that problem.
Yeah, well, I did. I paid the fine, but then I got a notice saying that I needed a medical check. So I went ahead and had a medical check done.
Yes.
And sent the information in from the doctor that was signed off. That was fine. I went on my merry way, didn't hear any more about it until I was picked up in Frankston a month ago, and they said, "You're driving on a suspended licence."
So
And
are
I
they
said to the
prosecuting
policeman,
you for driving while suspended?
they're not.
So how can I help you, Greg?
Well, all I'm saying is it's a word of warning that I actually said to the policeman, but I didn't know I was on a suspended licence. He said, "They won't tell you you're on a suspended
No, they
licence."
do tell you, don't they, David? They do notify
tell
you.
And it might well be. I mean, I understand that he was required to do a medical check, and sometimes licences are suspended if the medical check is not provided within a particular time. I would have said to somebody in Greg's position, I would be following with Vic Roads, the receipt of the medical check and details of the decision they make as a result of receiving it.
Hope that helps you too, and thank you for your call. Apologies to those people who were waiting who didn't get through today for a special Law Week edition of David Whiting Taking Calls. Next week, another special week. The week after Law Week is also special.
Thank you, John.
Look forward to seeing you then. Our talkback lawyer, David Whiting, helping you with free legal advice.